All right, so please take your seats. Let's continue with our LEX Talk segment. This is a format we started a couple of years ago, as in law, education, and experience, LEX Talks, and there's also about 2,000 legal tech companies that are called LEX something. And so we figured, we'll create our LEX Talks, and it's been a format that's been, I think, very well received. It's a great way to learn about important projects in an intense and concise way from people who are really doing amazing work and interesting work. And we have Nicole Shanahan here with us today, who will be emceeing the LEX Talks, as she has in, I think, the last 4 years or so. And Nicole, of course, was a residential fellow here at Codex in 2014, 2016, and she's stayed involved as a non-residential fellow since then. She's been a mentor to many important projects in Codex. She launched a couple of important projects here herself at Codex. And she's really, I think, sort of like set the standard of like running these LEX Talks, and so we're very happy to have her back. And Nicole, thank you so much for accepting our invitation, and I will turn it over to you. Please join me in welcoming Nicole Shanahan.
So this brings me to Megan Ma, who's our first LEX Talk today. Megan is a research fellow and the associate director at both Stanford Program of Law, Science, and Technology and at Codex. She has a long list of accomplishments, which include serving as the managing editor of the MIT Computational Law Report. She was a research affiliate at the Singapore Management University Center for Computational Law. Megan today is going to be sharing with us a broad scope of considerations needed when thinking through the nuance between standardization of LLMs and personalization of LLMs. She also has been exploring all the considerations the legal industry needs to be considering as we advance these technologies, asking foundational questions about quality of legal services, which I think ultimately just make us look at the state of legal services more broadly. Please welcome Megan.
So, how's everyone doing? What a morning we've had, right? So, it's clear that generative AI is making a sweeping impact on the use and integration of technology in the legal practice, but what about their application in legal education and training? Interestingly, professors Jonathan Choi and Daniel Schwartz designed an empirical study to analyze the impact of GPT-4 on the performance of law students on their final exams. They noticed that the starting skills of the law students mattered, such that those with the lowest performing saw the most performance gains with assistance using GPT-4, while the highest performing students actually saw performance declines. Choi and Schwartz suggested that LLMs may have an equalizing effect, potentially mitigating inequalities across learning abilities. While an exciting step towards understanding the impact of LLMs on performance, their empirical results remained rather limited, given that the study was rather narrow. Moreover, this does not necessarily answer the question, how could lawyers and legal professionals best leverage LLMs? In response, I focus on the future of education and training of legal professionals. Current use cases have been limited to applications of LLMs to assist with completion of legal tasks, but there is an empirical problem here. There are no clear definitions nor metrics around what exactly is a legal task and the requirements on ensuring that this task is done at a certain level of quality. Today, when we are asked about the delivery of quality legal services, example like what defines a good contract, what's a good brief, there is not one explicit answer. One of the complexities of the legal industry is that much of the work and value add is implicit, is tucked away by the personal experience and the specific know-how of the client and industry base. We presented last year at the International Conference on AI and Law our collaboration with senior associates and partners at DLA Piper. We asked them to annotate and identify clauses that they found were potentially conflicting or contradictory from a set of contracts. We observed that there were not only highly variable annotations, but that there were only 2 lawyers that seemed to converge on a set of clauses that they thought were contradictory. Even then, the reasoning was not the same, though both highly persuasive. This is because the greatest value add was for legal practitioners is precisely in the advisory component. More importantly, it is the advisory, this issue spotting, and the eloquence of argumentation that makes the work potentially diverse and highly varied. Accordingly, how do we describe the nuances of our legal work, capture and abstract from the lessons of practical experience? That will be our greatest asset. The ability then to translate this implicit knowledge enables us to build valuable training tools for our next generation of lawyers. What is fascinating is that until the recent advent of LLMs, the profession has been interested in questions of standardization, such as the construction of playbooks and templates, high-level descriptions of the practice. Yet in reality, we have attributed immense value in the opposite direction. That is, the legal profession values personalization, the wisdom of experience, the mentorship programs that exist internal to the legal institutions is a testament of the personality and narrative in this practice. At Codex, we have begun to experiment in this direction via simulation of legal behavior, as opposed to legal work product. Today, we will be demoing for the first time an alpha prototype of a simulator for M&A negotiations. Inspired by viral papers on generative and communicative agents using LLMs, we worked very closely with experienced M&A partners, Leonard and Conrad from Flatiron Legal, who are here with us today, alongside the original first authors, Hani and Hassan of the Communicative Agents paper, to develop a platform that would allow young lawyers to pilot and simulate negotiations at varying starting positions, extent of buyer-seller leverage, complexity of legal issue at play, and the impact on the deal. As opposed to training from a specific product, such as the term sheet or the main agreement, our first step was to bottle the wisdom of Lenny and Conrad and understand what they've seen in their years as leaders in this domain.
How would you measure up against a robo-counsel? As young legal professionals, we are often anxious and lost during our first client-facing interactions, particularly in high-stakes situations. So why not go through a pilot simulation to strategize, train, iterate, and perfect your negotiation technique? This will also enable your senior partners to provide more precise and targeted mentorship. This is the motivation behind our M&A negotiation simulator. So how does it work? I'd like to first disclaim that this is an alpha prototype. We are currently making updates to the UI UX, as well as improving on a number of fact patterns and tools to assist with the pedagogical training. Furthermore, this platform is focused on negotiation prior to the signing of a letter of intent and term sheet. This means we train the model on the premise of implicit expertise and not on any confidential documents. I'll now walk through a quick demo of how it works. You'll notice that there is the background and context of the negotiation featured at the top. Here we are negotiating an equity sale between a fictional buyer and seller. The buyer is interested in a seller that has a proprietary SaaS solution for small, medium-sized business retailers. The fictional buyer believes this acquisition could help extend its market presence and technological capabilities. Now we, as a lawyer trainee, have been assigned to represent the buyer. We start by entering our name. We then select the practice level as a junior or senior associate or as a partner. Depending on the level selected, the fact patterns will adjust accordingly. So if I selected junior, you'll notice that the main focus will be warranties and representations. If I selected senior, the main focus will then adjust to cybersecurity incident, followed by a description of the new facts that have since arisen. The original fact pattern of the equity sale remains consistent across the junior, senior, and partner level. However, new facts are added to the original fact pattern, depending on the level of difficulty selected. This is because we wanted the complexity of the simulation to mirror the impact to the deal. While senior associates could manage slightly more complicated incidents that arise and have an effect on the deal, partners are immediately involved when situations get nuclear. For the purposes of this demo, I'll walk through the senior level only. Once selected, the user will be informed that the seller disclosed of a breach in their customer data. The user is now recommended a few suggested topics of negotiation. You'll also notice that there is a hint button. A user may click on the button for a hint in the event they get stuck or are struggling with where to start. So if I hit this button, I'll notice that there's a tip about the known and unknown risks here to mitigate. Immediately I think, I should renegotiate our standing representations and warranties, and I better hash out this indemnification. I am now ready to kick off the negotiation, so I'll scroll to the chat and open up with the following statement. In order to proceed, we're going to need to be protected against liability arising from the specific incident. We're going to require a higher standard of protection overall with respect to cybersecurity and privacy. We now wait for the robo-counsel to respond. Once we receive the response, we can click on the audio button if we want to actually hear the robo-counsel.
I understand your concerns about the cybersecurity incident. However, I want to underline that Tachys took immediate action to remedy the situation and has complied with all regulatory requirements. Nevertheless, we acknowledge the potential liabilities that could arise from this incident. Thus, we propose to provide an indemnity against any damages related to this particular incident. Moreover, Tachys is committed to improving its cybersecurity and privacy protections. We are ready to work closely with Shopmaster to establish higher standards in these areas. However, any further protection measures should not disproportionately impact the purchase price or the general indemnity cap. We need to find a balanced solution that protects Shopmaster's interests while not placing an undue burden on the sellers. Let's discuss how we could shape these terms to ensure a fair deal.
So I'll think about whether or not I like this response. I might say indemnification is a productive approach. However, we should still be fully indemnified against any liability arising from this particular incident, where we may be willing to entertain a survival period and could be open to putting a cap on other incidents that arise in the future. Now we once again wait for the robo-counsel to respond.
Appreciate your willingness to negotiate on these matters. We understand your need for full indemnity against any liability arising from the particular disclosed incident. As for future incidents, would a survival period of years with a cap of the purchase price be acceptable? This would provide protection against future liabilities, while also giving Tachys some predictability in managing potential future risks.
So now once again I think about the response. I might respond with, I'm glad we're agreed to full indemnification with respect to the known incident. With respect to potential future incidents, we accept 3 years, but the cap of 15% is way too low. And if we want to hear the response, we once again.
I understand your apprehension regarding the proposed cap. Given the gravity of potential future cybersecurity breaches, we are willing to negotiate on this. How about we raise the cap of the purchase price for any cybersecurity or privacy-related incidents? This demonstrates our client's commitment to the continued integrity and security of the Tachys platform, while still maintaining a reasonable limit on their potential liability.
And finally, I might concede and say, fine, this works for me.
Great. I'm glad we could come to an agreement. We will draft the updated terms with the revisions discussed. This includes full indemnity for the known incident and
So voila, once the user has determined that it has reached a strong deal in representation of the buyer, we can conclude the negotiation and save the chat dialogue. This will then be shared as a document to the user's senior partner. If you'd like to know more about how we built this platform, we'd be happy to share more on the specific agentic model that we used and how this is both helpful pedagogically for trainees and the training of the LLM. We're so thrilled we were able to share this early alpha with you all, and we look forward to user feedback as we move to the next phase of development.
So there are certainly some knots to still work out, but inarguably there is incredible potential in leveraging LLMs for legal training. Not only are we excited about the improvements that can be made to this simulator, we are also excited about extending simulations across other areas of practice, such as deposition strategy, SEC examinations. So rather than perfecting the machine intern, assistant, or co-pilot, let's instead elevate the starting skills of our lawyers and build the next generation of experts. Thank you so much.
Wow, that was awesome. Good job, Megan. Your phone. Our next speaker is Barbara Taylor, who is DLA Piper's first knowledge officer. Her job is to ensure lawyers are practicing in an optimal way, leveraging the full swath of information available to them on any given day of practice. As I was studying your work, Barbara, I was really excited to see how you're tracking all of the developing legal AI ethics landscape, because that's got to be happening very quickly and in a very diverse way. And it is state by state, so can't wait to hear from you for that. So come on up. Thank you, Barbara. Please welcome Barbara.
Good afternoon, everyone. As DLA Piper's Chief Knowledge Officer, I am responsible for identifying, testing, and onboarding GenAI tools. 18 months ago, our leadership embraced the opportunity to be a pace setter in this realm because it's consistent with our brand as a modern, dynamic innovator. Our adoption journey has been a mix of excitement with some trepidation. Most of all, it has been a learning experience for me, my team, and across the entire firm. We are still learning, but we have picked up some tips along the way, so I'm going to share those with you today. Humans have always used metaphors to make sense of complicated concepts, and GenAI is no exception. GenAI has been compared to the wild, wild west. This metaphor likens the technology to uncharted territories with seemingly limitless potential. GenAI has also been called a prism. Just as a prism refracts light into a spectrum of colors, GenAI is seen as a tool that can refract and bend information, creating new and unexpected possibilities. Both of these metaphors capture the power and potential of GenAI, but they gloss over the complexity of getting hundreds of lawyers to actually use it. Deploying GenAI is a very different story. How do we get our smart, successful, but skeptical lawyers to use this technology safely, effectively, and ethically? The right metaphor for the DLA Piper story needs to capture the essence of an exciting but tricky journey with successes and failures along the way, but always building towards something groundbreaking. After a lot of thought, I decided that the DLA Piper GenAI journey is a lot like learning to play the game Minecraft. And yes, that is me. I am sure that many of you are scratching your heads, so let me elaborate. Let's start with our first lesson, look past the hype. We've heard a lot about hype today. Promoters from Minecraft have created trailers and other material that are polished and cinematic, showing beautiful scenes and animations, like this image you see here. But they bear little resemblance to actual graphics and mechanics of the game. Similarly, excited AI developers can, from time to time, be overconfident about their product's capabilities and downplay any weaknesses there might be. This, though, creates unrealistic expectations, which eventually leads to disappointment with our users. Minecraft is an established and successful video game, so that we know its players have gotten past the hype. But on the other hand, GenAI for legal is still quite new, So we have to be very intentional with our approach in this regard. The knowledge team at DLA Piper has developed several strategies for getting past the hype. First, when we, my team, attend demos, we assume that we are seeing the polished and cinematic version of the tool. We bring a healthy dose of skepticism to our evaluation process, but we also keep an open mind until we have tested the tool ourselves. Second, we expect and then plan for the attorney's expectations gap. As a result of all of this hype, our attorneys often expect a magic wand that will perform an array of tasks right out of the box. To counter that, we are very clear about capabilities, what the tools can do, what they can't do. We are also very clear about the learning curve that's involved in becoming a skilled user, and then we provide training and resources to help our lawyers get there. Lesson number 2, choose wisely. Minecraft players can purchase resource packs to customize their experience. Resource packs are collections of files that change the experience of the game. Choosing the right pack is really important because there are packs that can cause problems or conflicts. Similarly, it is crucial to choose the right GenAI tool out of a vast and ever-growing product field. What you see on the screen here is just a subset of what is currently available right now. Given how vast the field is, it is easy to get overwhelmed. You could also spend all of your time just looking at tools. So in order to not fall into that trap, we developed selection criteria. We have a number of criteria that we consider to be foundational. These requirements relate to the security, the privacy, and the appropriateness of the tool for legal. So for example, if we were looking for a tool to help us do legal research, we wouldn't be testing tools that were primarily for contract drafting. And then the final criteria is that the tool must meet a clearly articulated business goal. Tying our tools to business goals in that way not only drives attorney adoption, an attorney has told us I could really use help with this, they're clearly going to give it a try, but it also enables us to demonstrate return on our investment in that tool. Oh yeah, that's right. Lesson 3, test, test, test. Seasoned Minecraft players will periodically debug to identify and resolve issues with the game. But debugging isn't just about fixing bugs. It's a tool for optimization, for discovery, and for strategic play. Extensive testing of a GenAI platform does the same thing. My team's been able to optimize our lawyers' use by verifying capabilities and identifying performance issues. We can then use the findings from our testing to inform the guidance that we provide. This enables our lawyers to get the most out of the platform without a steep learning curve. We also learned that some tools can do more than developers anticipated. A few of the unexpected skills that we've encountered include creating an associate self-assessment based on our experience database, turning a litigation tracking spreadsheet into newsletter content, and creating meeting agendas. Finally, we've learned that GenAI tools have their quirks. My favorite example is that flattery in your prompt can get you a better answer, but an overly polite query tends to return a posh, British-sounding answer that includes phrases like, if you would be ever so kind, and if it pleases you. Lesson 4, make no detractors. In a Minecraft world, griefing is the act of ruining other players' creations or gameplay experience. Griefers may destroy buildings, steal items, kill animals, or just generally ruin the fun. We saw a similar but less violent phenomenon in our early attorney testing. A tester would have an initial experience that didn't meet their expectations, and then they would write the whole tool off based on that one experience. They then became a detractor. They would share their experience with other attorneys, including those that had not even tried the tool, and turn them into detractors. When I realized what was happening, I coined the catchphrase, make no detractors, because I knew it would be hard to bring those people back into the fold. So my team had to make sure that we weren't pushing technology onto lawyers that weren't ready for the current state of GenAI tools. Our make no detractor strategy has several elements. The first is that we don't push adoption. When we launched our first enterprise-wide tool, We let all of our attorneys know that it was available, but we only followed up with those that expressed interest. Second, at DLA Piper, you have to earn your credentials. That includes completing 2 mandatory trainings and a formal acknowledgement of our acceptable use policy. And then finally, when we need attorney testers, we reach out to people that we know are already GenAI enthusiasts, because from them we can get solid feedback without any frustration on their part. Number 5, expect and embrace change. Minecraft is a game that constantly generates new and random worlds. Each play session can present different opportunities and challenges, so players need to be adaptable, resourceful, and willing to explore, experiment, and learn from their mistakes. GenAI is also fast evolving and unpredictable, and that means that the tools do change over time. We've already seen that in 18 months, as well as their outputs. So our human users need to be flexible and responsive to those changes and be ready to adjust our approach and our expectations accordingly. And in this context, when I say human users, it's a combination of my team, because we are on the front lines. We're the first people to try new things, but then, of course, our attorneys. And since most of the people in my team and our attorneys are attorneys, change doesn't come naturally to many lawyers. And so we really have to be very intentional about this. We have to expect change, plan for it, and adjust our mindset accordingly. And then finally, lesson 6, let ethics be your guide. Minecraft is played in different communities that each have their own rules. Those rules are designed to promote a fair, respectful, and safe playing environment. And while Minecraft changes from game to game, the rules stay the same, and they provide a true north for player behavior. In our context, the ethics rules are our true north. 18 months ago, I knew that we were in brand new and evolving territory, and that felt risky. But when I thought about how to manage that risk, I saw that our existing ethical responsibilities provide a true north as well. We could effectively mitigate risk so long as we used GenAI in a way that was consistent with our duties of diligence, competence, candor, and others. This approach was then validated as we started to see more and more state bar associations and the judiciary provide guidance that was consistent with what we were already doing. So most of my Minecraft experience has been as the mom of an avid player. I have observed that the player and player community is just as important to a positive experience as the game itself. As you can see here, our adoption journey has also been as much about the humans involved as it has been about the machines. So given that, if I had to boil this down to one overarching piece of advice to me, to you, it would be that as you continue down this journey where technology is very much at the center, make sure that you don't lose sight of the humans that are using it. Thank you.
Thank you, Barbara, and welcoming next Tom Melling. I think I first met you, Tom, in 2014. I was a user of Serengeti for many years, and I was starstruck when I met you because Serengeti was the only system at the law firm that actually worked. And so now you're working on electronic service of process. Can't wait to see what you do with that. Please welcome Tom.
I am so excited to talk about technology for the legal profession. Let's start with paper. It is so much better than papyrus. And how about FedEx? I mean, you can get that paper almost anywhere in the US in a day for about $50. And hold on to your seats. Faxes. That's incredible technology. So for the next 9 minutes, this is a Back to the Future panel about one of the few remaining legal workflows that's still stuck in the paper process. So real quickly, just to lay the groundwork, service of process, it's the delivery of a writ summons, notice, or order by an authorized person to a person who is thereby officially notified and therefore have to be commanded to take some action. Now, specifically, what I'm talking about here today is service on entities. Because entities have to do business in a state, have to register, have a registered agent with a physical address for service of process. Now, what that means in any state, but especially a large state like Washington, if the registered agent address is in Olympia and the law firm is in Spokane, they've got to get that paper all the way across the state. So that leads to workflows that look like this. Basically, the issuing party, usually in connection with the process server, prints paper. And they drop it off at the registered agent. They plop it on a scanner so they can digitize it. They then deliver it to the entity who then downloads it. It gets worse, though, from an entity standpoint because they actually get more service in more different ways than just that. And this is the diagram that we have put together after talking with a lot of our customers and prospects. They'll get service at offices, at branches, via fax, via certified mail. And when they come in, people go, oh my gosh, it's a legal document. Better get it over to those legal people. So then there's an internal email, maybe it gets entered in a spreadsheet, saved on a network drive. So then someone's got to go in and triage that, figure out what it is. There are people at companies whose full-time job it is to find duplicates and weed it out of the process. So this has been described to us as the legal junkyard with documents going through the grand tour. And again, part of it goes back to the registered agent having this physical address. If I'm a law firm and I figure, hey, I can just take this stuff to the bank branch, or maybe I'll fax it so I get it there first and then I'll also send it in paper to the registered agent, that's what leads to this situation. So the ideal solution would be if entities could say, only service electronically at this website. And that might look something like this. So you've got a website, serving parties can come there, they fill out a form, they attach the document, and what they then get immediately is acknowledgement of receipt. Confirms the document that was served, the metadata that was with it, and it's fast, it's reliable, and it actually can be more trustworthy than a paper-based process. So what is the barrier that's preventing us from seeing this today? Well, it's the laws that require a registered agent and physical service at a certain location if you want to do it that way. And how do we overcome that? Well, we're starting to see companies do it voluntarily, both voluntarily willing to receive service of process and also serving parties voluntarily willing to serve. And the reason why this can work is it's actually beneficial on both sides. It's more efficient for both serving parties and the served party. They both save time, they save money, they're saving paper and trees. And if you design it the right way, it actually can be an interface where you can not only have served documents being served, but also it's being two-way response documents, like responsive documents to a subpoena coming back. We've all seen over and over again where the law doesn't keep up with technology, but what I believe is that as people start using the technology, then the laws will evolve. And in fact, that is what is happening today. So the financial industry has developed electronic standards for government agencies to serve legal orders. That standard is called the ANSI X 9.129 standard. It was adopted by the American National Standards Institute in 2020, and it's in use by over 20 agencies. Here's a quick data point about how effective this is. So Chase now gets more than half of their legal orders electronically, and 80% of those require no human involvement to go from start to finish. We're also working on a draft electronic subpoena standard. I'm part of the committee that's working on that. So subpoenas themselves can be in a structured data format and receive some of the same benefits. And then we're also seeing companies setting up websites. Some of them set it up so they say any and all documents, our preferred way of receiving them is electronic. Some of them say we only want subpoenas, for example, to be served electronically. So this is what my company does. So we have a matter management system that's specialized for third-party subpoenas and account garnishments, but we also have our product called Servport, which is essentially a tool that we provide for customers to create these electronic service of process portals. And when we work with a customer, what we're really doing is we're implementing a holistic served document management platform to streamline the intake with automatic routing and assignment. And real quickly, what a quick demo looks like is we help our customers create instructions as part of the portal, which can be very important for companies. Another important concept is to be able to wrap legal terms around the submission of served documents. So a website is up 24/7. If you get it at 1 a.m. in the morning, you want to say, look, if you serve it after a certain hour, you are agreeing it's legally being deemed to have been received the next business day. We work with getting it set up so they receive all documents or maybe a certain set. And when the serving party selects the type of document, they then fill out the form with the various information. You need to also think about how you might have to receive payments like witness fees or garniture fees. We have the process for them checking consent of the legal terms. When the serving party is ready to submit, they do that and they receive an immediate acknowledgement of receipt. Now, the template we use with our customers is the waiver form in Federal Rules of Civil Procedure 4. And it basically says we're acknowledging we received the document, but we don't waive any other rights or defenses that we might otherwise have. They usually add a little bit of other information. So in the context of a subpoena, we typically respond in 45 days. Our cost is usually $100 to $200, and we'll let you know when our response documents are available. In addition, there's this meta information that was provided with the document, as well as the consents agreed to. So I'll leave you with 6 key concepts and considerations for electronic service of process. First is the wrapping of legal terms and how it can be very effective in terms of an entity kind of protecting how service of process comes in. How do you capture payments, things like witness fees and garniture fees? Authentication. So you can have phishing in both a paper-based service of process and electronic, but with electronic, it's actually easier to put in place authentication to really know who is serving the document and where it's coming from. Fourth is enabling a two-way capability. So not only receiving the served document, but also sending responses back, whether it's an account garnishment, subpoena, et cetera. The fifth is how you will support the emerging standards that are developing relating to these data formats for capturing data at the source and high volumes of documents. And lastly, the question of jurisdiction and how do you deal with the concept of where was service physically occurring in the context of if you don't have physical service. Thank you very much. I hope you're having a great conference.